If your dispute is not resolved in a Workers' Compensation Commission telephone conference, it may proceed to a face-to-face conciliation conference and possibly then to an arbitration hearing. In the following scenario, we continue to examine the story of Harry, the delivery truck driver who has not been able to reach an agreement with his employer over whether or not his knee injury is work-related. It's been a few weeks since the Commission arbitrator held a telephone conference with Harry and his employer's insurer to try to resolve his dispute. Harry wanted his employer to pay for surgery on his knee and for time off work. His employer's insurer said that Harry's knee injury is not work-related and would not agree to cover the cost of surgery. The next step in resolving the dispute is a face-to-face conciliation conference. Conciliation conferences are used to attempt to reach an agreement between the parties without proceeding to formal determination by an arbitrator. Most conferences take place in Sydney. However, the Commission also regularly sits in regional and rural locations throughout New South Wales. Videoconferencing is sometimes used if the parties cannot travel to a conciliation conference. Harry's conciliation conference is taking place in Sydney. At this stage, each party is usually also represented by a barrister. At the conciliation conference, an arbitrator, usually the same arbitrator who held the telephone conference, tries to assist the parties to reach a resolution. During the conciliation conference, each party can split off to separate rooms to discuss settlement options and explore ways to resolve the dispute privately with their lawyers. The Commission arbitrator is neutral and does not communicate with one party without the other party also being present. Most disputes resolve at the conciliation stage without the need to proceed to a formal arbitration hearing. When this happens, the terms of the agreement are recorded in writing and the Commission issues a formal copy of the agreement. However, in Harry's case, the parties cannot resolve the dispute by conciliation, and the case must proceed to an arbitration hearing to be formally decided by the Commission arbitrator. Arbitration hearings take place on the same day as the face-to-face conciliation conference and are heard by the same arbitrator. If the dispute proceeds to arbitration, the conference room will be prepared for a formal hearing. It's important to know that the arbitrator is now responsible for deciding the outcome. At the arbitration hearing, the arbitrator is presented with evidence and submissions from both Harry's legal representative and the insurer's representative. Unlike conciliation conferences, the hearing is sound recorded. The audio recording is available to the parties on request after the hearing. Arbitrators can deliver their decision verbally immediately after the hearing finishes or a short time after. Otherwise, arbitrators are required to give a written decision and provide reasons for their decision. In Harry's case, the arbitrator has taken the option of writing a decision, and the Commission will issue this to all parties. Parties have the option to seek review of the arbitrator's decision, called an appeal, but only in limited circumstances. Either party has a right to appeal against the decision. An appeal application is dealt with by the Commission's President or a Deputy President. The President or Deputy President will usually determine the appeal after considering the submissions lodged by the parties, but may also hold a formal hearing where further information is required to be presented. The written appeal decision is issued to the parties. If you or someone you know has a dispute about a work-related injury, the Workers' Compensation Commission can help. We have information available in many community languages. Visit our website to find out more.